You've seen it in movies and TV shows 100 times. The defendant suddenly claims they're crazy, walks free, and somehow beats the system. But here's what Hollywood won't tell you about the insanity defense. It rarely works, and when it does, the defendant doesn't walk away laughing. The insanity defense succeeds in less than 1% of all criminal cases. That's right, less than 1%. So why does everyone think it's this get-out-of-jail-free card that crafty lawyers use to help their clients escape justice? Truth is, way more complicated than what you see on screen, and some of the most famous cases in American legal history show us exactly why this defense exists and why it's so hard to use successfully. Let me tell you about John Hinckley Jr. On March 30th, 1981, he shot President Ronald Reagan outside a Washington hotel. The whole thing was caught on camera. There was no question he pulled the trigger, but his lawyers didn't argue he was innocent. They argued he was insane. Hinckley was obsessed with actress Jodie Foster. He'd watched the movie A Taxi Driver over and over again, and where the main character tries to assassinate a presidential candidate to impress a woman. Hinckley thought shooting the president would make Foster fall in love with him. His lawyers presented evidence of severe mental illness, including detailed psychiatric evaluations and testimony about his delusions. The jury found him not guilty by reason of insanity, and America lost its mind. People were furious. How could someone shoot the president and not go to prison? But here's what most people missed. Hinckley didn't walk free. He spent the next 35 years in a psychiatric hospital. That's longer than most people serve for murder. The public outrage was so intense that many states changed their laws. Some got rid of the insanity defense entirely. Others made it much harder to use, and that brings us to the real question. What exactly is the insanity defense and how does it actually work? There are different legal standards, but the most common one is called the Monotton Rule. It comes from an 1843 case in England where a man named Daniel Monotton tried to kill the British Prime Minister but shot his secretary instead. The court established that a defendant can only use the insanity defense if they didn't understand the nature of their act or didn't know it was wrong because of a mental disease. That's a really high bar. You can't just be mentally ill. You have to be so severely mentally ill that you literally don't understand reality. And even then, it's not guaranteed to work. Take Jeffrey Dahmer. He killed 17 people between 1978 and 1991. He kept body parts in his refrigerator and ate some of his victims. His lawyers argued he was insane. They brought in psychiatrists who testified about his severe mental illness and bizarre behavior. But the prosecution argued that Dahmer knew what he was doing was wrong because he tried to hide his crimes. So the jury agreed. They found him guilty, not insane. The difference between Dahmer and Hinckley wasn't the severity of their mental illness. It was whether they understood their actions were wrong. Hinckley was living in a fantasy world where he thought his actions would lead to a romantic relationship. Dahmer knew he needed to hide what he was doing. But even when the insanity defense works, it's not the easy way out that people think it is. Andrea Yates drowned her 5 children in a bathtub in 2001. She suffered from severe postpartum psychosis and believed she was saving her children from going to hell. Her first trial ended with a guilty verdict, but an appeals court overturned it because of prosecutorial misconduct. In her second trial, the jury found her not guilty by reason of insanity. Yates has been in a psychiatric facility ever since. She's not free. She can apply for a release, but only if doctors determine she's no longer a danger to herself or others. That could be never. Many people who successfully use the insanity defense spend more time confined than they would have in prison. Here's another thing most people don't know. The insanity defense is different from being incompetent to stand trial. If you're too mentally ill to understand the charges against you or help your lawyer with your defense, the court can find you incompetent. That doesn't mean you're not guilty. It just means the trial gets delayed until you're competent enough to participate. That's what happened with Jared Loughner, who shot Congresswoman Gabrielle Giffords and killed 6 people in 2011. He was initially found incompetent to stand trial because of his severe mental illness, but after treatment, he became competent and pleaded guilty. He's now serving life in prison without parole. The system tries to balance 2 important principles. First, we don't want to punish people who are so mentally ill they don't understand what they're doing. That's not justice, it's just cruelty. Second, we want to protect society from dangerous people whether they're mentally ill or not. That's why successful insanity defenses usually lead to long-term psychiatric commitment, not freedom. The person gets treatment instead of punishment, but they're still locked up until they're safe to release. Some states have tried to find middle ground with something called guilty but mentally ill verdicts. Under this system, the defendant goes to prison but receives psychiatric treatment. It's controversial because critics say it's just a regular prison with therapy, not the specialized care that severely mentally ill people need. The reality is that the insanity defense is rare, hard to prove, and doesn't lead to freedom. Most defense attorneys won't even try it unless their client is obviously and severely mentally ill. It's expensive, requires extensive psychiatric evaluation, and often backfires because juries are skeptical. Here's what makes it even more complicated. Mental illness doesn't automatically equal insanity under the law. You can be depressed, anxious, bipolar, or have other mental health conditions and still be legally sane. The law only cares about whether you understood your actions and knew they were wrong. That's why serial killers almost never succeed with insanity defenses. They might be mentally ill, but they usually know their actions are wrong. They plan their crimes, try to avoid getting caught, and lie to police. That shows they understand the nature of their actions. The whole system reflects something important about how we think about crime and punishment. We want to hold people responsible for their actions, but we also recognize that severe mental illness can make someone not truly responsible for what they do. It's not perfect. Some people who should be in psychiatric hospitals end up in prison. Some people who should be in prison end up in hospitals. But the insanity defense serves an important purpose. It acknowledges that justice isn't just about, punishment. Sometimes it's about getting sick people the help they need while protecting everyone else. So the next time you see a movie where someone fakes being crazy to beat a murder charge, remember that real life is different. The insanity defense isn't a loophole. It's a narrow exception for people who are genuinely too mentally ill to be held responsible for their actions. And even when it works, it's not a free pass to freedom. Thanks for joining us today at Due Process Daily. Throw us a like and consider subscribing to the channel to help us grow.